Any mention?
May I please your lordship? I beg to mention item number 4, lordship.
4.
Due to personal difficulties, this matter must become up to 2 weeks, lordship.
Yeah, no objection, Your Lordship.
4. After 2 weeks on the request made on behalf of the Lord and Counsel of the petition.
Highly blessed.
May I please your lordship? I beg to mention item 11 for 2 weeks here.
Yes.
I am
11.
for respondent, Your Lordship. No objection.
When do you want it?
After 2 weeks. Lordship.
Item 11 also same order.
Apply, lordship. May I please your lordship? I beg to mention item number 12, your lordship. I pray for 3 weeks time, your lordship.
My lord, I am the sole respondent. I have no objections, my lord.
Much
Obliged.
obliged, lordship.
May please, lordship. So I beg to make a mention for item 5, lordship.
Yes.
I pray the matter may come after 2 weeks, lordship.
Other side?
No objections.
Again same.
Highly obliged, lordship.
May back to item number 7, Your Lordship.
Yes.
Opposite party is Mr. Chanda. He's from Guwahati. So he's not well, so he just requests me to.
You are
I'm
mentioning.
I'm
you are
for the
mentioning on
opposite
behalf of the
party.
petitioner.
I'm for the opposite party.
You
So
are
Mr.
mentioning on
Chanda, he's tell me that nobody will be there, but
that is what I'm saying. You are mentioning on behalf of the petitioner.
I-
Nobody
I-
is there on his.
I may mention because of this opposite party will not be here, and he's sick. So due to the reason,
Can you appear for the opposite party if a
no,
petitioner and
just
the
I'm
respondent
mentioning
same
this
time?
one matter. The opposite party, I cannot inform me. Already he's informed me. He will not be
Shall
informed.
we make an entry that you are appearing for both the parties here?
There it is. It is required to mention to the opposite party, but yes, this.
See, none appears for the petitioner. Just number 7 okay, on the request made by Mr. R. Dharmat, Planet Council appear for the respondent. Planet CGC, isn't it?
Yes.
Appearing for the respondent. This is matter after 2 weeks. Okay.
May I please your lordship?
Yes.
I beg to mention number 8, 9, and 10. I'm praying that this matter may be taken up after 2 weeks.
9 and 10 also.
8, 9, and 10. They are all connected matters.
Yes, who is appearing in for the 8, 9 and 10? The other side?
Lord, we are for the state, Lord.
Okay, 8, 9 and 10 on the request made on the petitioner. Just after 2 weeks.
Highly obliged.
Obliged.
Your Lordship, another matter is this item number 15. Come 2 weeks, Your Lordship.
This is a POXO matter for quashing, my lord. Husband and wife. So, connected matter similar is already pending.
Send the request made. And we have the petitioner. This after 2 weeks. Item 15. Yes.
Supplementary list, item number 1.
Yes.
May I please your lordship? Lordship, I have filed an application under section 482
It has come on recusal.
Lordship.
Yes, Lordship.
Why? It was pending before, right from beginning, before one bench. Why suddenly now?
Lordship, upon going through the cost title and going through the writ petition, His Lordship has found
But
that
then,
there
right
is
from the first day, it was before that court, isn't it?
Lordship. Yes. Some of the respondents are known to.
Okay. What is
So
the
now it is at the stage of Lordship filing of the affidavit by the
Counter affidavit, Lordship.
respondent number 9 to 11. Enough.
private respondents? 9 to
Yes,
11
Lordship.
Yes, Lordship.
Lordship.
Lordship, for respondent 1 to 8, it's already filed, the affidavit. 9 to 11 is still left, Lordship.
1 to 8.
Yes, rejoinder had also been filed, Lordship.
One is Union of India.
One is Union of India.
From 2 onwards, all are
They are
respondents
officials,
by name.
Lordship, yes.
They are all respondents by name.
By name, because
So all have filed separate affidavit.
One affidavit, Lordship, on 30th January 23.
Was there not implement in their individual capacity? Their name party by name.
respondent number 2 had filed an affidavit even for the Union of India that we have objected, taken the ground in our rejoinder.
No, once a party becomes party by name, then it is deemed that they are made party in their individual capacity.
Lordship.
Anyway, then at least and especially you filed a common affidavit. That is also
Lordship.
very.
For the 1 to 8.
What is the matter about? What is the prayer here?
Prayer, Lordship, here in this writ petition is that initially in the year 2017, writ petition was filed by the petitioner before this honorable court, and the court, after hearing the petition, has disposed of with a direction, certain directions that the respondent should treat him as per the with other.
What is the
students.
grievance? That
Grievance at that time was, Lordship, that he was maltreated. He was not treated as per other students, and he was
the
facing
writ petition has
harassment.
been entertained.
Entertained, and it was disposed
can
of.
it be a subject matter to be adjudicated in 226?
Lordship, it was disposed of, and now and that the direction was given that when he leaves the university, at that time no adverse remark should be made, because at that time the Lordship bench could foresee that since he had stood against the
It
institute,
was a direction of a single bench.
single bench, Lordship, and not challenge, and it
Can
has
such
attained
type of-
finality.
Can such type of direction be passed?
Lordship, it was given, and then
Before a person completes his tenure in an institution, can this order be passed that no adverse remark should be passed against him without knowing what he will do for the rest of his career, what conduct he will maintain? Can it be done?
but those
This kind of direction, can it be implemented?
Lordship, yes, because now he had completed his course, he has left the university,
So what remains?
and
there?
then remarks was made against him, adverse remarks. Against that,
That
we
is
have
after-
come
after
for
he
quashing.
left. After he left.
Yes, Lordship, after completion of his
No,
course.
no, but then that remark is with regard to the period when he was not there.
No, Lordship.
So now you want that expansion of that.
Yes, Lordship,
How
for
the
quashing.
Reed Court will entertain that? What expertise Reed Court has to do it? You will make allegation, they will come with counter allegation. Then how this court will determine?
Now
We do not have any original jurisdiction to be exercised. There must be some remedy within your institution.
Lordship, I have.
It is from Nigrims.
Yes, Lordship, I have availed those remedies also, Lordship. Filing representation, even complaints, those were not. And even those complaints were also, I am seeking direction against those complaints also to be disposed of within
What is the
time.
highest authority of the hospital?
Is the Union of India, Lordship, Law Secretary,
No,
Health and
of the hospital.
Lordship.
There is no executive council or something like that.
Lordship, that is not.
That is there. You verify. I don't think that your remedy will be ever here.
Lordship, even the students' grievance cell is not there.
It's okay. Maybe, but then there has to be something. See, this kind of dispute, I don't think that jurisdiction will be appropriate for us. Then you have to go somewhere else. Not here. Think of it. Anyway, what is to be done today?
Lordship, since as per the last order, Lordship, we were supposed to file counter affidavit, Lordship, for respondent 9 to 11.
You are representing 1 to 8 also.
1 to 8,
And
9 to 11.
also.
Yes, Lordship.
So why 9 to 11 are from different institution?
Yes, Lordship.
That's why you are seeking time for filing affidavit.
Yes, Lordship.
Okay, so
Lordship, I pray for some more time, Lordship.
yes, Mr. Upadhyay.
Lordship, it may be given as a last chance, Lordship.
Today is the first day before this
Oh,
court, so
yes,
court will not give
yes,
us.
that is.
Okay. Ms. Pradhan, Learned Counsel, appearing for the respondents. Praise for grant of some time for time to respond number 9, 10 and 11 to enable them to file their counter affidavit in the matter. The prayer has not been opposed by Mr. Upadhyay, Learned Counsel for the petitioner. Stop accordingly. Further 2 weeks time is granted to the respondent number 9, 10 and 11 for filing their counter affidavit in the matter. List thereafter.
I do, Lordship.
Yes, fast, yes. Thank you.
Supplementary causeless or bailess, item number 1. Bailess, item number 1.
Yes, Mr. Shulai is not there.
For the petitioner, Mr. P.K. Bora is appearing.
None appears for the petitioner. Mr. H. Karni. Learned G is present for the respondent number 1 and 2. This is matter after 2 weeks.
Lordship, yes. Yes, Lordship.
Item number 2.
You're appearing.
My lord, before my learned senior proceeds, I'm making a prayer on behalf of Madam Angela. She's not keeping well. So I pray the matter can come after 2 weeks, my lord.
Is it this is a matter ready for hearing?
Lordship.
This will go for hearing then.
Lordship.
Okay, prayer has been made on behalf of the learned senior GA. On the prayer has been made to adjourn the matter on the ground that the learned senior GA appearing the matter is indisposed.
Yes, my lord.
Mr. S. Panthi, Learned Counsel for the petitioner, submits that the matter is otherwise ready for hearing. Accordingly, this is matter for hearing after 2 weeks.
Lordship, right.
Item number 3.
Yes.
Yes, Lordship. Yes, Lordship, last order, we have taken steps with regard to respondent to serve any Lordship.
My lord.
Yes.
It please, your lordship. So far as the state is concerned, we have a very limited role, my lord, in this.
What the respondent number?
District council.
So why district council? For district council you have taken steps. There is
Yes,
standing council.
We have taken steps, Lordship.
There is a standing council. How you have taken steps?
Lordship,
Taking steps will delay the things.
no, Lordship, we have tried to serve to the council, Lordship, but it didn't accept, Lordship. They said you have to serve directly to the district council, to the secretary, Lordship. We have a copy, Lordship, of the notice that we have received.
You have issued it by registered ID.
No, Lordship.
But
SP
then here
lordship.
it says notice has been issued to the respondent by registered post with AD. You check the office note. Anything remains in this matter to be decided.
Lordship.
What?
Lordship, as per a
This
prayer,
interim
Lordship.
order has taken care of the final disposal.
Lordship.
Then
Actually, Lordship, in our prayer, one of our prayer in this matter has been disposed, Lordship. One part of our prayer, Lordship.
and you filed how many petitions? 2 petitions.
Yes, Lordship.
One has been disposed of.
Lordship.
What about the other?
Not yet, Lordship.
Which one has been disposed of?
An application to provide a copies, Lordship.
So once it is done, that is okay. Second is automatically complied with.
Lordship,
See yours, or what is your second application?
Lordship, as per my
To
instruction,
conduct
Lordship.
the final hearing after providing the copies. The matter has become infructuous, you can close it.
No, Lordship.
Why no?
Lordship, also by instruction.
Once you say one is complied with, that means 2 is also complied with.
No, Lordship. Actually, Mr. Paul is leading this matter, Lordship, so
He is not needed. A senior counsel is not needed for all purposes.
I pass it
You
over,
will not come
Lordship.
and appear for this thing. You will not come here to say these things.
No, Lordship.
It is too small matter for him.
No, Lordship. Lordship, I'm praying to pass it over for today, Lordship, so fix it.
Anybody
My
appearing
lord,
for the
just
private
nothing
respondent?
remains in this petition, my lord.
You serve a notice to the council for these things, standing council for the district council.
Lordship.
Okay, from the office note. Actually, office note indicates that the steps for service of notice upon the number 227 has been taken. However, delivery report in respect of all the respondents. Delivery report in respect respond number 4 to 6 has not been returned. You do one thing. None appears for the respondent number 2, 3, and 7. Though it appears that notice upon them has been served. Stop. Just say use service report from respondent number 4 to 6. List after 2 weeks.
Much
Come with instruction. We should not keep this kind of things pending. Useless.
You're obliged.
Supplementary cause list. Hearing item number 3.
May I please, Your Lordship?
Yes.
Your Lordship, I have taken step, Your Lordship, on respondent number 4, Your Lordship.
Now, what is the address of Staff Selection Commission? You do not appear for Staff Selection Commission.
Your Lordship.
You cannot accept notice on their behalf.
Lordship, I'll seek instruction, Lordship.
In such a case, this hassle of this service and all takes unnecessary time. What is the address of Staff Selection Commission? Merely writing Staff Selection Commission would not do. You do not have a staff selection office here in Assam also, in Guwahati also you have.
No, Your Lordship. This address also we just get from this form, Your Lordship, which is an annexure 1 in.
Annexure 1.
Yes, Your Lordship. Page 9.
Okay. So what you will do? You will verify the status of service.
Yes, we'll just wait, Your Lordship. You'll see in the next list whether they appear or not.
Oh, you have taken steps only.
On 19, Your Lordship. 19.1.
What is to be done now?
Now let's wait, Your Lordship, for some time.
It appears that the service report on respondent number 4 has not come. Await service report, list of returns.
Kindly please, Lordship.
All right.
Item number 13.
Yes.
On the last date of hearing, the learned investigating officer had appeared before my lord and had given certain clarification.
That has been settled.
Lordship, that issue has been settled. He
Yes.
asked for an apology.
So today, my lord, it is listed for your lordship's consideration on merits.
Yes.
I had already extended arguments in this matter on previous occasions. So if it pleases my lord, I can just reiterate my submissions.
Ready for.
Lordship.
What is the issue? No, there is a quashing application.
Quashing.
Quashing, my lord. Quashing of FIR. If I may draw your lordship's attention to page number 19, that is where the complaint is, which is forming a part of the FIR. Page 19.
Yes.
Please, my lord. My lord, this is addressed to the officer in charge, Bonihart, and this is dated 18th of August 2022. First-hand information, respected sir. This is to bring to your notice that I, Mayank Sharma, resident of so-and-so,
Any
have a
private
complaint.
respondent here? Any private respondent here in this case?
No one has entered appearance till date. Service has been affected, my lord.
Service has been affected and no one has appeared.
No one has appeared.
You are appearing what?
No.
Sure, she's
She's
there.
my colleague. She's my colleague. Please.
So private
Yes,
respondent
my
has
lord.
not appeared in spite of the notice. Okay. Yes,
Please,
proceed.
my lord. Have a complaint against Mr. Sandeep Kumar Bhagat, owner of Sai Megha Rolling Mills Private Limited, having its location at 15th Mile, Ponihat. I'd like to inform you that I had supplied raw materials to Mr. Sandeep Kumar's factory for conversion of the same into finished goods. In spite of taking the entire raw materials amounting to around 1 crore at that time, that is almost 4 years back, which now would not amount to less than 1 crore 65 lakhs. I have been continuously trying to communicate with Mr. Bhagat, but all in vain, as he has stopped responding to any calls or messages despite of sending
Who
various
is Mr.
reminders.
Bhagat? Who is
Mr.
Mr.
Bhagat
Bhagat?
is the named accused in the matter. He is a businessman based
Then
out
who
of
is Mr. Sandeep Kumar?
Sandeep Kumar Bhagat, my lord. He is the accused, the
So
named
then
accused.
first part is Sandeep Kumar, second part is Bhagat. Anyway,
Yes, yes. Sandeep Kumar Bhagat
he's the same person.
is
He's
the
the
same
same
person, my
person.
lord.
Yes.
Yes. Sandeep Kumar Bhagat, owner of Sai Megha Rolling Mills Private Limited. So now coming to that same line, my lord, as he has stopped responding to any calls or messages despite of sending various reminders, I am going through a huge financial crisis. Hence, request the honorable to take action against Mr. Bhagat and help me recovering my amount, which has been long overdue. I shall remain thankful forever and obliged for the same.
Yes.
My lord, in my most respectful submission, this is a purely civil dispute which concern a time-barred claim. As per the complaint itself, it says that all of these transactions had been affected 4 years back. Till date, my lord, there has been no civil claim that has been filed before any court. This is just an exercise to put the criminal machinery into force to gain some wrongful gain in the matter. I'm on a very, very small point. I don't want to burden the court with any further arguments.
But there is no question of burdening. Issue is very similar.
Please,
It's
I'm so
not
obliged.
a allegation of crime against society. It comes out of a individual thing, and there is no allegation of like criminal misrepresentation. Yes, Mr. Khan, what you will say? Issue seems to be very, very small, and here an FIR has been filed for seeking recovery of the amount.
May it please your lordship. Lordship, it appears, if you read the FIR, it appears, but there are three arguments I need to forward, your lordship. Three arguments. First is this is regarding quashing of an FIR. And quashing of FIR, lordship, will not burden the court by repeating Bhajanlal and all. Whether if the contents of the FIR discloses an offence or not. First thing is this, whether
Probably we all know those propositions.
so you know, sure, whether it now the issue is whether it discloses an offence or not. Now we have to overcome that part of it. If it discloses an offence,
Where is the offence disclosed here first?
I'll come to it. Whether the FIR discloses the offence or not. Prima facie, the allegation that is stated in the FIR is 1 crore and 165 4 years back.
Why you are going with the amount?
I'm not going with the amount, Your Lordship. It's regarding. I'll read to it, Your Lordship. I would like to inform you that I had supplied raw materials to Mr. Sandeep Kumar's factory for conversion of the same to finished good. Lordship, this is a very important line. Allow me to repeat again. He supplied to Sandeep Kumar factory for conversion into finished good. In spite of taking the raw materials amounting to, let's not come to the amount, raw materials so and so, now would come to 164. I have been continuously trying to communicate with Mr. Bhagat, but all in vain. He has stopped responding to my calls message despite of various reminders. Two things is very important in Lordship. Supplying of raw material for conversion. If you keep aside the amount. Now supplying the raw materials and conversion into a finished good. Let's pause for a minute here. I agree what is there in the background. If there was an agreement, terms condition of an agreement, we can understand
Why
that.
you are making submission lengthy things? Just tell us one thing. Is there any allegation?
Absolutely, serious allegation.
Say,
For 420. It comes
how,
within the
how?
meaning of
On
420.
what basis you say?
419, 420 Lordship. 406.
Why? Is there anything to show
Lordship.
that Mr. Bhagat has ever induced or he has misled that person?
Lordship,
There is nothing.
Lordship,
It is a voluntary this thing.
Lordship,
What
that
has
is-
been done?
Lordship, that is there in the case diary. In the investigation.
See, in the FIR, we are just confining to the FIR.
Lo-
The private party has not entered FIR.
Not entered
in spite
FIR.
of this.
Ah.
That is okay. That is good enough.
No, Lordship, that's why the limited issue, Lordship, is this.
Okay, we'll record your objection. No problem. We are bound to record your objection.
Lordship, first is this. He has supplied raw material to Sandeep Kumar for conversion into finished good.
It is a voluntary. He has supplied it voluntarily.
Yes.
He has never said that he has been induced. He has
It's
been
not
forcefully
been
forced.
induced. Lordship, the investigation clearly says there was no written agreement.
What are the ingredients of 420? If you say 420, just what is the ingredients of 420?
420, Lordship. Because 3 sections have been charged: 419, 420, and 406.
Okay.
Criminal
We'll see-
breach of
we'll see-
trust.
We'll take into consideration the ingredients.
So we have to read the ingredients of 420. First, Lordship will come to 406.
What does it 420 says?
406 is criminal breach of trust.
Anyway, just let us finish your submission, sir. 420. You say there is an allegation under 420 and all.
It comes within the meaning of allegation under 420 and 406.
And 406 is criminal breach of trust.
Criminal breach of
How
trust.
criminal breach of trust is this thing?
Because, Lordship, it was given on trust. There was no written agreement. So it will be a matter of investigation and filing of the charge sheet whether it will come within the meaning of 420 or 406. Lordship will just come to 406. Whoever commits criminal breach of trust. See, it's a different matter whether 420 will per se will be applicable or not. That is a different issue, Lordship. The issue is this: whether the FIR discloses an offence, and what offence.
Come to the definition of criminal breach 405.
Lordship. Whoever being in a manner entrusted with a property or with any dominion over property dishonestly misappropriate or converts to his own use the property or dishonestly uses or disposes of the property in violation of any direction of law prescribing the mode in which such trust is to be discharged or any legal contract express or implied which he has made touching the discharging of such trust or willfully suffers any other person so to do commits breach of trust.
So where is that thing in allegation in FIR?
Lordship, allow me to read again. Then, whoever being in the manner entrusted with the property.
Yeah, that is okay. Come to
Raw
the condition.
material
Yes,
was
entrusted with the
entrusted.
property
Raw material was entrusted to.
or with any dominion of property.
Lordship, allow me to pause. I understand the
No,
language
you
of
see, if you allow pause in a certain area without these things, if you say whoever being in any manner entrusted with the property.
He was
Property
entrusted
has
with
been
the property. Raw material was entrusted.
Definitely.
Lordship.
And that was done voluntarily, isn't it?
Lordship?
That was done voluntarily.
Mutually. It's there. I'll come to the investigation.
Then
part
what
of
is the difference between mutually and voluntarily?
Here-
Mutual act will not be voluntary.
it. Mutually means there
Once
was
you say
no,
mutually, that will mean any force.
not enforce
Then
lordship.
why you are playing juggling with the words?
No, lordship, I'm not juggling.
Mutually, what is the mutual thing will not be voluntary.
It has not come in the FIR. Lordship, I'm aware of.
If you say give a proposal today, I agree with it. It will not be voluntary. It will be mutually. And which you voluntary and mutually differ.
Lordship, because the FIR does not speak, so difficult. Again, I will not. Lordship, I have the FIR in the background only.
Yes.
Lordship is very correct. Lordship is very correct.
Okay, 420, 406, and then
40, Lordship. So,
you say element of 40420 is there.
420 is there, Lordship.
Yes.
Now, Lordship, the FIR clearly says after the raw material was converted into finished good, the amount was for 1 crore.
Finished good means what? What goods it would have been?
It is not described, Lordship. Let us be very frank, Lordship. It's not
So
described.
we do not know what is finished.
We don't know, Lordship. And Lordship, had it been an agreement, we don't know exactly.
Agreement need not be.
Need
otherwise
not be.
written.
Lordship is correct. Lordship is correct.
Yeah, there is something called verbal agreement.
Absolutely. So, Lordship, let's take here this a verbal agreement. What is finished good? We don't know. Matters under investigation. So, Lordship, allow me to pause here for a minute now. Raw material convert into finished good. Now, Lordship, I will, from here, what is happening in the investigation is very important. Police has issued notice thrice to the petitioner, that means the accused, under 41A.
Yes, that is perhaps on the other day when the CD was called for, it was noticed. It was noticed.
So, Your Lordship, notice and thrice, police has visited to his house twice, knocked the door, lady comes out and says not here. Twice, thrice. If see his conduct, Lordship, kindly appreciate that part of it. If his statement came or he would have cooperated under 41A, and he would have explained to the police what exactly was the finished product, what was the money paid or not paid, it would have been a different situation. Now he has not at all cooperated with the police. Neither he is complied. Police should have arrested him. His Lordship is aware. 41A non-compliance, the sixth step would have been that. Now why was he fearing non-compliance? Just to assist the police on giving explanation was what is the finished good. This part is very important, Lordship. Conduct in an implied contract. This shows that he is not cooperating with the police and there is something that he wants to hide.
So these are the development which after FIR was filed.
Lordship, yes.
So this fact will be attached to the allegation made in the, will be added to the allegation made in the FIR.
Lordship.
And then the criminality of the thing will be decided on that. Okay.
Because had he cooperated, Your Lordship, the implied that would have been clarified.
If he had cooperated, then implication would be that this is not a criminal offence.
Lordship, at least that version may have come out. I'm not supporting. Lordship
We
is
will
correct.
record your submission. Just trying to get what you are saying. That will be reflected definitely. We will deal with it.
His conduct was very crucial, Your Lordship. Choosing not to cooperate with the investigation and then appearing before the High Court for quashing. See his conduct. What was he fearing? It was not an arrest warrant, it was 41A.
Yes.
And then, Your Lordship, in the case diary, there is a message.
Any decision to show that the relevance of non-compliance of 41 in quashing matter?
Lordship, to my humble submission, I have not come across that. But I'm relying on Section 8 of the Evidence Act, Lordship. Section 8 of the Evidence Act is the law which is...
Is it applicable pre-trial stage?
No, it's not applicable.
Then?
It is not applicable in the stage of quashing. Lordship, in the stage of quashing, I am aware of it, a very small window is there whether it discloses an offence or not. Only the word discloses an offence.
You see, you yourself started with the proposition laid down in Bhajanlal's case.
Lordship, so my submission is...
going somewhere else.
Lordship, if I could have closed my case only in 1 minute saying that it discloses an offence of 406 and 420. But court had a query and wanted to say where is the dishonest intention in the FIR. Lordship, I'll frankly admit That language is not there.
The question was confined with regard to the FIR, not to the any other.
Absolutely. The Lordship, that clarity was not there, but
See,
then
it was expected that you will base your reply by taking into consideration allegation made in the FIR, and you will say, you will give your version.
Absolutely. My Lordship, my reply
go
was
somewhere real what happened after the FIR has been
no,
filed.
Lordship, I am not going into that because Lordship had called for the case diary. In last 3 days, Lordship wanted to see.
That is because of that other confusion.
That confusion was there.
Case diary was called because of the another thing, that is.
Otherwise, Your Lordship, the ingredients of 406, 420 is prima facie made out because there is no agreement, and then an implied contract clearly says that. Why I am coming to subsequent conduct of his, Your Lordship? Why I am coming to subsequent conduct? He is not cooperated and he has come to the High Court for quashing. So all these things are irrelevant for the purpose of quashing.
One thing is that this is allegation is not with regard to the commission of any crime against society. Do you agree that? The allegation made here, the sets of allegation, if at all consider it to be,
Lordship will kindly appreciate 406, 420 does not involve crime against the society. It can be a dispute between two people in a private level.
That is what exactly this court is saying.
Yes.
So you agree with
Yeah, I agree. It's not against society. Lordship is correct. Lordship, as usually I don't want to
now,
burden the court.
If you say the private respondent has chosen to remain silent even after the issuance of notice, your state.
Yes. So what I am saying is this, Lordship, if he was see his conduct.
But it's not a crime against society, at least.
It's not a crime against the society. And what was the Lordship will kindly appreciate, not that it has got any relevance for quashing of an FIR. I am aware of it, Lordship, that my argument on 41A has got nothing to do. But then he was aware of everything. He never cooperated with the police. Neither he is cooperating even now. Only there is a WhatsApp message where he says, "Thoda der hoga, RTGS होने से मैं दे दूँगा." That evidence has come.
Doesn't matter which way they would.
That is irrelevant again for purpose of quashing of an FIR. So some investigation has progressed on the basis of
this has been FIR was filed in 2022.
Yes.
And it is more than 1.5 years.
1.5 years.
Almost 1.5 years. Now in the second. So charge sheet has not come yet.
Charge sheet has not come yet. Matter still under investigation. Otherwise, Lordship, had those other development not taken place, I would have said, Lordship, kindly appreciate the only limited issue is this. The FIR does disclose an offence. Now, what type of offence, whether it is 406, 420, at this stage, even I can't forward an argument, Lordship, because matters are
we are not required to go into
it. We are not required to go into it. Lordship is correct. It discloses. So my summation, Lordship, would be, I've just brought in the other part of it because it is not cooperating. But that is not relevant for the purpose of quashing of FIR. If you read in minutely, finished product, supplied raw materials for conversion into finished product. Again, Lordship is correct. Money is immaterial. It could be 1 rupee, it could be 1 crore. Now, that allegation is there. Investigation is on, Lordship. At this stage, whether whether caution will be required.
The FIR was filed 4 years after the supply of raw materials.
Lordship is correct. We don't know had the private.
It took 4 years for maker of the FIR to realize that he has been cheated.
Look, as per the WhatsApp communication, he was in touch regularly. WhatsApp communication is on, abhi de dunga, and there is communication. And we still don't know, Lordship. If it was an agreement, we understand. Lordship is correct.
Petitioner is not here to say all those things.
Petitioner is not here to say all those things. But there was a communication, and the communication went on for quite some time, and then nothing happened. All needful purpose would be served if the offence has been disclosed. Then it's a fit case for investigation. We don't know finally what will be the outcome, whether it will be charge sheeted under 424.
The matter remained pending for 1.5 years. See, the case has been registered under 419, 420, 406.
Police have tried many times to go and meet him. Had he cooperated and still managed charge sheet, we understand, Lordship.
We are talking about the finalities. We are not on
exactly. Lordship is asked.
You are travelling somewhere else, Mr. Khan.
Lordship is correct. Otherwise, Lordship
is all those facts
are irrelevant for the purpose of quashing. Yes, I agree with you.
Okay. He is not cooperating or cooperating. You see, he has come because he has approached this court because he felt aggrieved by the filing of this FIR.
Absolutely
He is
correct.
felt aggrieved by the police action. That is why he is here. Otherwise, he would not have come here.
Your Lordship is correct.
So that is
Absolutely.
all.
The only limited issue is whether it discloses an offence. If
So,
that is the only limited query, Your Lordship.
Surrender to police is not a precondition. for
Absolutely
seeking
correct.
quashing.
Lordship, absolutely correct. That would have been, Lordship, that would have been relevant only for the purpose he could have explained. He could have explained.
See, that is where, say, like whether each and every allegation requires explanation
No.
to police or not.
No, not required.
So that is what.
No, Lordship, because we have, Lordship,
Police will seek explanation from a person.
Lordship, can you appreciate the submission forwarded by the petitioner counsel? His case is a civil dispute. He has started his argument with civil dispute. Now, how, as a state, am I going to defend that, Your Lordship?
No, see,
What is the basis for him to tell it's a civil dispute?
all case of commercial transaction, you cannot say these are all confined to civil dispute.
Absolutely.
And just
Lordship
because
is-
something involves a dispute of civil nature doesn't mean that it will not be regarded as a criminal.
Absolutely.
Both-
And Lordship, I don't want to
Many
burden,
decisions-
Lordship, I don't want to burden the court with judgment. Even if criminal case is, civil dispute is there, the criminal case can go on.
Definitely.
And,
There are
well,
judgments
there's no
by the
bar,
court.
no bar. There are judgments. There is no. Had he argued on that, though it's a civil dispute, so this criminal case has to be quashed because the civil matter has to be agreed.
He has not finished.
No,
Like,
he is not.
He may argue now.
If that would have been a different.
Probably just after the reading the FIR, we have jumped.
Absolutely. Lordship's query was very loaded query, Lordship. That Mr. Khan does it disclose an offence. So prima facie, Lordship, I would have had a very limited ability to reply except on that Bhajanlal if it discloses an offence. And if it discloses an offence, Lordship, I would have to read only 406, 420. And I would have to rest my case there because there is the only argument to answer your Lordship query. But then since he started off by saying it's a civil dispute and there's nothing on record. Or there's nothing on record to say. Had he said it is a civil dispute and they have filed a civil dispute and I should have gone to it or they have gone to it, this FIR is unnecessary, then there's a different level of argument. But had he started off by saying it doesn't disclose an offence, which the query fell from the court, then I had to limited reply. That is the reason we are going not into jargons, Lordship, but we are answering questions which are irrelevant because he started off as an irrelevant argument. That's not his case. And Lordship's query was the only relevant thing. Does it disclose an offence? All other arguments are irrelevant. I agree with your Lordship. All other arguments are relevant for the purpose. It does.
Let us just see. Yes, Mr.
Please, my lord.
Mr. Das, am I correct?
Please, my lord.
Yes.
Yes.
What would be the effect of the development which takes place after investigation progresses to a certain extent? And if that investigation reveals the presence of some criminal element, what effect it would have in the quashing petition?
Please, my lord. So, my lord, I am very grateful that it had already fallen from this court that the subsequent developments will have no bearing while deciding
Well,
an
that was the
application.
primacy word. Is that what like if the
Yes.
court has not come to conclusion?
Please.
The question was put to the learned AG here also is the same thing, or the learned special prosecutor. That what bearing it would have in the question application. Now, what is your submission on that?
My lord, in my most respectful submission, the subsequent developments will not have a bearing as long as I am able to satisfy the court that on the face of it, there is no commission of criminal offense. As such, my lord, on that aspect, I say that even if I take everything on the face value today, the complaint that has been filed and eventually culminated into the registration of FIR, there is no disclosure of any criminal offenses. For the ingredients of 420, there is misrepresentation, inducement, and delivery of property. These are the three ingredients that we follow from the Indian Penal Code. My lord, even if I take everything on the face value, in my most respectful submission and for your lordship's consideration, no such offense has been made out.
So you want to say the non-supply of materials or the finished product would not constitute any criminal offense?
No, but my lord, but in order to
It may happen
jump to
like
the
that. It may happen like that. When you procure the order, you have one intention, and subsequently your intention changes. Then what happens?
then the offense will be made out.
So how do you determine your subsequent intention?
My lord, here,
Is it
if
not
I
that
go,
we take into consideration the development which has taken place by investigation to determine your subsequent for the purpose of determining your subsequent intention?
no, I follow. I
Can
follow what
we
is
do it? Can we do it? You see, this court may ask you many questions. It may not. It may be something like that. Each and every query of the court is correct. You see, you have to correct the court.
No, please. So obliged.
So tell us, can you take into consideration for determining your subsequent intention?
In my respectful submission, it might not have a bearing.
Why? On what basis?
As long as I am able to satisfy to the court that even if I take everything on the face of it, still the offences will not be so made out. Today, my lord, there is a lot of assumption. If we go back to the complaint, it says that the raw materials amounting to 1 crore was given 4 years back, which would not be less than 1.65 today. So
Give
all
up,
of
give
these,
up. Forget about that. This valuation will not do in a criminal proceeding.
please.
Okay, just leave aside that thing. But then the fact remains, the allegation is that you have taken something with the undertaking to return it as a finished product,
Please.
which you have not done. And
I follow.
in spite of several requests, you are not doing it, and now you have disappeared. You are not attending the call also. So now, whether your disappearance will not cause any criminal, will not be taken as a criminal offense, because your intention becomes apparent by your act of disappearance.
Yes, ma'am.
So what you will
follow.
say on that?
My lord, if there is evidence to back this particular situation, then yes, the offences will be made out. But I say in this case, there is no evidence that has been attached
See,
in relation to the
your case is not based on evidence. You are basically basing your case on FIR, and you are saying that
FIR.
even this entire fact or entire set of allegation is accepted in toto, that will not make out a criminal case. That is what your case is.
I'm on a very limited aspect.
That
Yes,
is
please,
that is
ma'am.
what. Now this court understands. But then the FIR contains one thing that you see, like you have disappeared. You are not responding to the calls and all. So does it not that your criminal intention becomes apparent from that fact? Even if we are to analyze the allegations made without going into the depth of the things, whatever the prima facie appears.
It definitely will have a prejudicial effect.
So then
If
in
there is
such a case, your
there is
case
a-
fails. Your case fails.
My lord, as per instructions from my client, I had specifically sought this clarification whether any 41A notice in relation to this matter was
No,
served.
we are not gone to that
The answer
41A.
was in the negative.
We are
So
just
I'm
confining ourselves to the FIR. We are not taking into consideration Mr. Khan's submissions on the which has been made on the basis of 41A.
please.
Only thing is that here on allegation is that despite of sending various reminders, I have been continuous trying to communicate Mr. Bhagat, but all in vain, as he has stopped responding to any calls. Is it not that your intention of cheating becomes apparent here? If
My lord,
we accept this allegation.
if there is evidence to back this, then yes. Then the
No,
ingredient
evidence
of
to back this, that will become a fit case for trial.
yes.
Right now we are on quashing. Once you are on quashing means you do not want any investigation to proceed on the basis of this FIR. Okay. Now, just going by the argument which you have made, we accept this entire allegation is correct, and we also say that your non-response to the call is also correct. Will it not be good enough to show your criminal intention at this stage? Do not.
My lord, it might have a prejudicial effect, but as far as the powers under 42 is concerned to secure ends of justice, my lord, to that extent, the court will still be empowered, I feel, to, even if this is taken in the affirmative.
No, no. See, there is no question. You see, there is no question of the authority of the court. Court has enough authority to interfere with the FIR if it finds that there is no disclosure of criminal offence. Now, the query of the court to you is confined to the fact that your failure to respond, as has been alleged in the FIR, will it not constitute the projection of, wrongful intention on your part?
Wrongful intention, yes, but
No,
if
if
I
you
go
say,
back,
then your case goes there. If you say yes there, then your case goes there. Then we will say
so
that
it's
this is a case for, not a fit case for caution.
please. But my lord, I am in totality saying, denying this particular aspect of the matter.
No, that
I
is
am
okay. You
saying
see,
that,
but then your argument, basic argument before this court is that if we accept the entire version made in the FIR as correct, okay, then also it will not make out a criminal offense against you.
that is my first argument.
That
Second
is
argument is, yes, there is no disclosure of any criminal offences qua 406 and 420 as the ingredients are not so met. This is
yes.
my second leg of the argument.
That is all right. We understand that. So that is why, just going by what you submit, which way we should take your non-response to the calls made by the maker of the FIR? Which way it should be seen?
So if we accept this particular aspect of
Yes,
the
yes,
matter,
yes.
that certain calls had gone 41 in notice so served, and I have not responded.
No,
I
no,
have
no.
not responded.
41 is not coming here. Confined to the
Okay.
FIR. Confined to that line, what allegation has been made. Please read this line. I have been continuously trying to communicate with Mr. Bhagat, but all in vain, as he has stopped responding to any calls or messages, despite of sending various reminders.
Please, madam.
Is it not, whether that statement is not sufficient enough to project your intention before a court?
But will it touch upon the three major ingredients of 420 is a question that I put to myself, that there is misrepresentation,
Yes.
inducement, and delivery of property. As was pointed out by this honorable court, that whether this particular issue will have any kind of inducement effect.
See, why you are basically confining your argument to 420? The charge can be altered at any stage. You may file on
Right.
FIR, it can be recorded under one section of law. Subsequently, it might end up filing charge sheet in some other section of law.
Please.
Then we are not basically confined to the issue whether a case under 420 or 406 has been made out or not. We are basically on the issue whether it at all makes up any criminal offense or not, irrespective of the fact it falls under which section of law.
Absolutely.
So that is what you have to address.
I follow.
That is what.
So, no, I follow what is falling from this court. So, my lord, if today it's a case that I take 1 lakh rupees from someone,
Yes.
and tomorrow I am supposed to return that amount basis some agreement, which is not in this case, but basis some agreement, and then I stop responding, I go missing.
Yes.
Am I right in the analogy, my lord? I'm trying to understand what is falling from this court, that I go missing and I stop responding, whether the offences would be made out. Is this the query that has fallen from this court?
See, whether there is an agreement or no agreement, we are not commenting on that because we do not know as of now. Nothing has been stated in the FIR that where there exists any agreement or not. Okay.
Right.
Now, but then one thing is that we say that the supply of raw material was voluntary. Definitely, you see, you have no part, you have not induced him. Okay, or there was no coercion from your part in how to do it, or misrepresentation by yourself. That much is correct. But then what happens when the FIR says or speaks about the development which takes post supply? Okay, you run away from him whenever you see him, you avoid him. Is it not the basically it's a kind of you see like projection of criminal intention on your part?
Whether that kind of response or behavior will attract the offences, I am not very sure. It will have a prejudicial effect, I say.
See, see, the question is again, you do not come to that thing which you have already said, that whether it will constitute offence under 420 or 406 or not. This court is on that question, not that question. If it makes out any offence under any other section of law also, then also you see you will not have a case for quashing. If you go by the mandate of law or what has been laid down in Bhajanlal's case, it is to make out whether a criminal offence has been alleged or not. It is irrespective of the fact the offence under what section of law or not.
Please.
You must be aware of the fact that the investigation authority is not bound to submit a charge sheet under the section of law like which was registered at the time of the registration of the FIR. That option always remain upon. They may find that is offence under something else.
Please.
So what you will say about that part?
My lord, I will hold to my original argument, and rest I completely bow down before this court that the ingredients are not touched upon.
So your argument still will be that even if you do not respond, this will not make out a case under 420, or
And
this will
406.
not make out a criminal offence. What you will say? What would be your contention?
There is no adverse influence.
But I had already highlighted the ingredients.
No. That
So I
see, what is your overall argument? That the allegation made in the FIR does not constitute any offence under 420 or 406.
that is
Or you want
one.
to say, or you want to say that it basically no offence can be made out, even if
My lord, yes. If everything is taken in totality in the affirmative, still it will not reach the basic ingredients of the sections. That is my prime argument.
any law, you are relying on any law.
I will file a compendium with the judgments. I have not
No,
attached
it is
any.
not. Have you given? As
No, I have not attached
isn't
anything.
today.
I will file a compendium if so directed by this honorable court.
No, it is not required. If it is up to you whether you require to furnish anything to advance your argument or not, to support your
Please,
argument. If you do not want, why the court should insist?
No. If it falls in any way in the area of assisting this
No,
court,
it's okay. There is no issue of law is involved here.
please.
I don't think this matter is very complicated. But then it was only for what is the progress of investigation, Mr. Khan?
Lordship, because of none, 41A stage is stuck up non-cooperation. Caesar list has been made of the WhatsApp details.
Why you are confined to 41? If he doesn't come, you will not charge sheet the matter.
No, Lordship asked me what is the stage. I said that it is stuck up at that stage.
So you are. It means the investigation also is not processed.
Not proceeding, and then Caesar has been
When
made.
41 notice was issued,
Caesar has been made over the WhatsApp communication.
that is okay. When the 41 notice was issued?
41A notice, Lordship.
On which date?
कहाँ पेज हूँ? नहीं 41A नहीं यहाँ पे रुका डेट कब है?
Is it on 12/6, 2023?
23/19A.
So that is also almost after 1 year of the filing of the FIR.
Lordship. डेट ही नहीं लिखता ये लोग. One is at 26/8 2022, Lordship. 26/8 2022.
26/8 also you have sent this thing 41A notice.
26/8.
26/8. Where it is?
Lordship has got a case there. Copy.
There is a copy. Initially, it was submitted at the time.
Lordship, can I just? I'll flag mark it.
That's all right. It's all right. Just this is for perusal, nothing else.
Exactly.
May
Lordship.
not be much relevant for the purpose.
Absolutely
of this
correct. Absolutely correct. Yeah, I'm grateful, Lordship. After the query thrown by the court to the petitioner counsel, the real issue has come out. Because all through he was arguing on civil dispute. That is why I had to deviate.
What has come out, we do not tell now, Mr.
Had he confined only to FIR, things would have been
Court is
different.
yet to decide on anything.
No, absolutely, yeah, Lordship, we leave it to the discretion of the court. Absolutely correct. And then 13/6/2023 also, Your Lordship, notice was sent. 13/6/2023. 41A notice.
The 13/6/41A notice means it is almost after 10 months of the filing of the FIR.
Yes, Lordship. Yes.
Why so late? Even 41A also you took so much of time for you to.
That is very sad. The level of investigation I can imagine, Lordship. And then Caesar list was prepared. WhatsApp messages, Caesar. Lordship is correct. Eventually, we don't know which way this case will go, charge sheet under which section what, but the way investigation also progress also, it leaves much to be desired.
Mr. Nongpir, you are there. Watch out with him. Not
My
against
colleague.
him. Not against him.
Not again.
He's not against. Sit down, Mr. Khan.
Right. I thought maybe any other query, Lordship? No.
No, this is.
Police from Assam also was taken. Assam police also. Still then.
Yes, Mr. Das, anything more?
No, my lord. I'm so obliged.
On the last occasion, you made submission that since the claim has been barred by operation of some law, this FIR was filed.
Yes, my lord. So, my lord, if I draw your lordship's attention to the complaint again, my reference point is Mr. Sandeep Kumar Bhagat, owner of Sai Megha Rolling Mills Private Limited. My lord, I said that there is no company with the name Sai Megha Rolling Mills Private Limited. Factually, in this entire process, there is no such company. In fact, there are 3 other companies wherein I'm a director. That I have highlighted in my brief facts leading up to the petition. If your lordship is pleased to see page number 4 of my quashing petition.
So you say no such rolling mill at all exists?
Yes, my lord. With this particular name and style, there is no such company. If I am permitted to draw your lordship's attention to page number 4 of my petition, I have highlighted the exact name and description of the companies. At page number 4, specifically 5A. My lord has it?
Yes.
5A.
Yes.
Yes, if I'm permitted to read, that the petitioner herein looking for business expansion and other opportunities and took credit-based facility from PNB with respect to his company, namely Sri Sai Alloys Private Limited, Sai Rolling Mills Private Limited, Sri Sai Smelters Private Limited. So, my lord, that these 3 companies.
These omissions are radical in nature, it seems like.
No, I understand, but I'm just clarifying that this particular name, as is appearing in the complaint, there is no such company that exists. All these companies are under liquidation. There is a liquidator who has been appointed, and even that particular stage has come and gone, wherein claims were put before the public at large, the society at large, and this particular gentleman, the complainant herein, did not so approach with any legit claim, if there is. Which is anyhow a factual aspect which I'm just bringing to your lordship's attention, nothing beyond.
It's all right, but then this may not be much relevant.
Not at all. Hence, I am not burdening this court because it's a matter of factual basis. So I just thought I'll apprise this court.
It's all right, but then I don't think this will be much relevant.
Please, ma'am.
When your name has been mentioned, had there been no mention of name, or may not?
Yes.
Please.
Yes, Mr. Khan, you'd like to add on anything?
Lordship, in fact, this would have been my first argument in reply, but because of so much of issues raised, and my conclusion, Lordship, would be that the FIR, law on FIR is very settled that whether it discloses an offence, and it has rightly fallen from your Lordship. Offence doesn't mean 420, 406, so these are matter of investigation.
That is what the Bhajan law says. You should disclose an offence.
The word offence, Lordship.
Yes.
Whether it discloses offence, and I'm grateful to your Lordship. Lordship raised up the second part of the FIR where the repeated call was, so that if you read both the parts, raw material, goods, and not responding to call. If you read three parts, there are 3 parts clearly discloses an offence. The submission would be, Lordship, it is a case where the FIR discloses an offence, and so it's not a fit case for being quashed.
So we can conclude the hearing?
Please, madam. So obliged.
Hearing concluded. Reserved.
Grateful, Your Lordship, at least first case of the year where we have concluded the hearing. I said first case of this year we have concluded the hearing. Nice way to start off.
See, this court has many other matters also. You see, like if more matters are kept reserved, then...
No, ideally it's not, and matters like...
See, like if judgments are not delivered in time, then it is useless keeping it reserved also. So we have to make a balance of that. That is the main thing.
And Lordship, kindly please just accommodate with us, because with the setting of the new division bench, sometimes maybe
that we understand. No, that is we understand. Mr. Khan,
it's not that
see, these genuine requests are never refused.
Absolutely. Yeah, I would love to argue, Your Lordship.
Only thing, as you know,
I always like to argue before.
As you know, there are when there are too much indulgences, certain parties they
very true,
try to take undue advantage. There is no. Okay. So, thank you.